Hello friends, I welcome you all to my channel. Let me thank you all first of all for your overwhelming response for my first video. That actually inspires me to make the another one. And so here I am with the very concept of doctrine of prospective overruling. Now once a decision given by the Supreme Court, it provides certain effects. As a very general rule, a law or the decision once given by the court or a particular law which is an impugned law, which because of the very decision of the court declare as unconstitutional, then the effect of that decision, generally what we are understanding, that it deemed to be in effect in prospective manner also and in retrospective manner also. So it means that whatever past transactions taken place with reference to that impugned law, the decision will be applicable to that transactions also, and at the same time, henceforth from the date of that judgment, under that particular impugned law, whatever transactions are due, that will also be nullified by this particular judgment. So this is the very effect of the very decision what we are understanding. Next, that every declared unconstitutional law is void from its inception. So as I told you, that once a law enforced in the system, from that inception, from the date of enforcement itself, that impugned law can be treated as unconstitutional in that particular legal system. That is also a very general effect of a judicial decision. Next, that judges they not invent the law, but they discovers it. So when they are discovering the very existing norms of the system, and they are not something newly injecting in the system, so but naturally we have to understand that application of that particular judgment against that impugned law should be applicable to the past, present and future transactions. And so these are the very effect of judicial decisions what we are understanding. And now with this backdrop, let us come to a very basic issue what our topic is we are discussing. What is prospective overruling? Now prospective overruling is contradicting with the this particular aspect what we now discuss in regards with the application of a particular decision in regards with the impugned law in a retrospective manner as well as in a prospective manner. Now the concept of prospective overruling is giving exception to this particular rule, and it provides that the application of a retrospective effect of a particular judgment should be diluted and prospective effect only upheld in the legal system, and that with the judgment of the court of law, court is undertaking, court is guaranteeing that the effect of this judgment should not be applicable for the previous transactions, but it should be applicable for the future prospective transactions only. It means that the doctrine of prospective overruling is excusing the very precedential rule of a judicial system. As you remember, under Article 141 of the Constitution, it says that a law once declared throughout the territory of India, or law which is decided by the Supreme Court within the territory of India, that should be final and binding throughout the courts within the territory of India. It means that prospective overruling is excusing that particular rule of precedent which actually overrules the past decisions also, because in this prospective overruling we are applying that particular judgment only in the future date but not in that particular past date. So it means that under this concept of a prospective overruling, the decisions effected for future transactions only, and so whatever settled precedents they are there, that settled precedents will be overruled, but that settled precedents will be overruled from the future transaction and not from the past transaction. That is the very crux of this particular doctrine of prospective overruling. Next, from where it comes? So let me put here that the USA, and in the USA the Linklater versus Walker, this case was decided in 1965. There first time they refer this concept of prospective overruling. Now instead of going into the facts of the case, in that particular judgment what they said, that the impugned law which is held invalid from the date of decision and not earlier. Now in this we have to understand, if you could compare US and the Indian legal system in regards with the doctrine of prospective overruling. In US, the law which was challenged in the court of law, that is the impugned law, they held as invalid from the date of decision and not from the earlier. In Indian context, I.C. Golaknath versus State of Punjab, in 1967 this case was decided, and in this case 5 judges out of 11 judges, they refer the concept of prospective overruling. Now in this particular case, it was a very new version what originally we understood from the US legal system adapted in the India. How? In this particular case, it was held that by these particular 5 judges in their judgments, that all amendments till the decision remains valid forever. Only principle of non-amenability of the fundamental rights was to apply in future. Now in this particular regard, we have to see the difference between the US and the Indian judicial system in terms of doctrine of prospective overruling. Because in India we are applying the doctrine of prospective overruling only in regards with the amendments whatever taken place in the Constitution, and in that we are saying that all amendments till the decisions, all amendments till the decision of this I.C. Golaknath, they remain valid and they remain valid forever, whereas from the date of judgment or the decision in US, the law which was challenged, that law will be treated as invalid. So there is a difference, that we are contradicting with the US model of prospective overruling while interpreting that particular doctrine in Indian context, because the impugned amendments in our system we are validating and we are not nullifying that particular amendments. Only the very principle of non-amenability of the fundamental rights in future we are upholding while referring the doctrine of prospective overruling in this particular case of IC Golaknath versus State of Punjab. Another, in US, this doctrine applied in general manner. So wherever the question of interpretation of constitutional provision came to or arose in the system of US, they are applying this particular doctrine in general. Whereas in India, this doctrine is applied only to declare the legality, validity of constitutional amendments. So if any constitutional amendment challenge, to check the legality, validity of that amendment, if there is a court at their discretion thinks that there is a need of application of a doctrine of prospective overruling in that particular case, then only they can apply that particular principle. Even in IC Golaknath, Supreme Court held that this doctrine is restricted only in the jurisdiction of Supreme Court only. So no other court, they have the jurisdiction even to apply this particular doctrine. So these are the very comparative points we need to understand in regards with the US legal system of application of doctrine of prospective overruling and Indian legal system in regards with the application of doctrine of prospective overruling. Next, circumstances of application. Why there is a need to apply this doctrine? What conditions warrant us to import this doctrine from the US and to apply in the very system of Indians? What deadlocks created and because of which we upheld the application of this particular doctrine of foreign import within the territory of India. So circumstances in this, when the retrospective overruling causing administrative inconvenience, then the judiciary can take recourse of doctrine of prospective overruling. Retrospective application may disturb the vested rights of the citizens. Then in that case, the doctrine of prospective overruling becomes inevitable in that particular system. When there is a hardship which is created in regards with the life, liberty of the citizen, lives of the citizen, or in regards with the business transaction, property transaction, then in that case also, in those circumstances also, the application of doctrine of prospective overruling can become a very reality. When it disturbs the elaborative administrative arrangement already taken place, if suppose you are applying the decision from the past date and already the government or the state made elaborative administrative arrangement under a particular law or the impugned law, then in that case judiciary may think that it would be a very unfair to destruct that particular arrangement, administrative arrangement. So in that situation also they can apply the doctrine of a prospective overruling and they can effectuate that decision from the future itself. Now in Indian context, there is an extension of this particular doctrine, and that there was a landmark judgment in the form of a Mundell Commission, which is known as Indra Swani versus Union of India, 1992, the year in which this case was decided by the court of law. And this case was in relation with the reservation to the other backward classes basically. Now why we are saying okay, in this case we are having the extension of this particular doctrine of prospective overruling, or this is a case which gives us extended version of doctrine of prospective overruling. As I said, 1992, in this year this case was decided, and in this case the decision of Rangachari, which was decided in 1962, that was reversed by the court of law. Now in this case, court ruled that the decision which is the reverse of that particular Rangachari's case, and they applied that particular decision after the 5 years of the date of judgment. So to nullify that Rangachari's effect, whatever transactions of promotion taken place, without affecting those transactions, Supreme Court tried to soften the very two complicated or conflicted interests of the society, that is the advantageous class and the disadvantageous class. And so for the convenience of the transaction, Supreme Court held that whatever transactions already taken place, without affecting those transactions, we are from this particular judgment, from this particular decision, we are declaring that in future, and that is after the decision of this particular Indra Swani, after 5 years, we are applying this particular judgment. And so in these particular 5 years, the very gap which provided for the settlement of transactions in regards with the promotions whatever already taken place in the system itself, and for the smooth operation of law of promotion, and to settle the conflicting or competing claims of advantage and the disadvantage sections of the society, court actually postponed the application of this particular doctrine for 5 years. And that's what we are understanding it as an extended version of that US model, what we are understanding. So in this case, while validating the very promotion or right to have the promotion in the services for the SCs and STs, the court gave that particular ruling in which the application of judgment will not affect from the future transaction or in relation with the future transaction, because already that transaction has been taken place, and whatever positions held by such respective candidates of that respective categories, it would be unfair to revoke and reverse that particular transactions. So instead of reversing that transactions, will validate that particular transactions, and further for the 5 years we are not applying this particular judgment, and after the date of this particular judgment, after the gap of 5 years only, this judgment will be applicable, will came into effect. So this is something which is we are again deviating from the US model in regards with the doctrine of a prospective overruling. So this is what we are understanding as an extended version of a doctrine of prospective overruling in this particular case. So very crux I have told you, and I expect that you understood this. So if you like this particular video, please share and subscribe my channel. Thank you for watching this video.